Thank you very much for the invitation and welcome. Good afternoon. Welcome to this lecture, and I would like to be less of a lecture and more of an interactive seminar, maybe. So if you have any questions, don't hesitate to ask, and I will also ask you. So please don't hesitate to not answer, but get involved. The lecture or a seminar is about surrogacy. And it will not be so much about some definite answers, but more of about questions that every country needs to ask and find their own answers to when the country wants to regulate surrogacy. And the Czech Republic now is on the brink of, might be on the brink of a specific regulation of surrogacy. So I believe these questions will, and I hope these questions will be debated in this country pretty soon. So, what actually is surrogacy? Undoubtedly, you all know what it is. There's no codified definition, but we can say that surrogacy is an arrangement where a woman, a surrogate mother, gives birth to a child for a couple that is sometimes called a commissioning couple or intended parents. And these intended parents then want to raise the child, intended parents. There are more types of surrogacy, and one of the crucial types is altruistic surrogacy, which is not done for any kind of financial or other remuneration. Altruistic, so the surrogate mother gives birth to these intended parents just out of goodwill. She wants them to have a child. Usually this is carried out by a relative or a close friend, a sister of the woman who wants to be the mother, and so on. And then there's commercial surrogacy, which is done for financial remuneration, obviously. And in law, we like to go back to the Roman law, and those old Roman lawyers used to say, mother is always certain. And they used to add, father is always uncertain. But mother has always been certain. But is she now? Because today, sometimes we simply have to deal with a brand new question. Who should be the mother? Or what should be the relationship, legal relationship between perhaps more mothers and the child? Because now we have a gestational mother, the one who carries the child and gives birth, and a social mother, the one who raises the child. And of course, okay, if a lady gave birth to a child and, for example, gave the child to adoption, this used to be distinguished in all ages and all times. But now we have a third type of mother, and it's a genetic mother, the one who donated the egg. Or gestational mother and genetic mother might or might not be the same person. Sometimes we also say that traditional surrogacy is surrogacy when it is the same person. The gestational mother donates the egg because today usually a child is created by IVF and not by more traditional methods when it comes to surrogacy. But there is gestational surrogacy, and gestational surrogacy usually means that a genetic mother and a gestational mother is a different person. So, so far so good, but when facing surrogacy, we might come to certain dilemmas, and different people will solve these dilemmas very differently, based on their values, based on their culture, based on their politics, based on their religion, and so on. So, for example, how would you decide in these cases? The first case, a young married couple wishes to have their own children, biological children, but it then turns out that the wife cannot conceive a child for some medical reasons. The sister of the mother offers to bear the child altruistically. She doesn't want anything for it. She just wants to help her sister out because she knows her sister dreams of having children. And she wants to conceive via IVF from her egg and the husband's sperm. So, who of you would allow surrogacy in this case? Okay, most of you would allow surrogacy in this case. This is probably the most allowable case imaginable. Like, of course, there are people and there are cultures that have a great problem with surrogacy per se. For example, the Catholic Church bans IVF and bans surrogacy as well. for reasons that probably are beyond the scope of this lecture. But if someone agrees with some kind of surrogacy, they usually agree with this kind of surrogacy. What about this one? A single lady in her late 30s wishes to have a child through surrogacy. She might be able to have her own child, but she doesn't want to be pregnant. Since she has a successful professional career, she can pay for a commercial surrogate. Who of you would agree with this? Okay, and now it's entirely different. Wow. Okay, just one or two of you. What is the difference for you? What is the deal breaker between the first and the second case for you? Those of you who answered differently. Okay, she has a choice. So she could have, and if she couldn't have her biological children via natural means, you would say, okay, this is all right as well. Yes. Okay. Thank you. Anyone sees it differently? Any other deal breaker? Or this is the deal breaker for all of you? Yeah, she has a choice. Because this is one of the things that usually or very often is highlighted by the critics of surrogacy. They say, okay, it might be allowable, it might be permissible when it is a cure for some medical issue, even though some people say, okay, it's not a cure, we only circumvent the medical issue, we don't really cure it. But anyway, those people say, okay, it might be permissible for medical issues, but not for this. And some women, of course, use surrogacy just out of convenience, or perhaps she knows someone who died in pregnancy. It can happen, even though today pregnancy is much safer than it used to be. The whole human history, it is still a condition that is not exactly safe and not exactly comfortable. Some women suffer from very serious conditions during surrogacy. Perhaps she has some experience, perhaps she knows about it. Yeah. And perhaps she just wants it because she just wants to go ski in the winter, and perhaps she just doesn't want to slow her career. Okay, and this is one of these issues that is widely discussed. So we might come to it later, back, but now, what about this? The brand new experience of the mother. Imagine a situation when there is a young surrogate mother, a young lady who gets along well with the commissioning couple and agrees with all the clauses of the surrogate agreement. Because sometimes the commissioning couple or the intended parents come into a legal agreement with the surrogate. So she agrees with everything. They just sign off the documents and go along with it. And then when the child is born, the gestational mother suddenly changes her mind. And she says, okay, this is my child. I want this child. I will not give the child away. And the commissioning couple says, okay, but we want the child. We had an agreement. We have an agreement. How would you decide in this case? Okay. Who of you would say that the surrogate mother should have a legal obligation to turn the child to the commissioning couple? Okay, most of you, yeah. Wow, great. It's a great question. So for you, the deal breaker here would be, who is the biological mother, the genetic mother? Okay. So if we suppose that the genetic mother is the one from the commissioning couple, you would be for you would vote for the obligation of the surrogate to give the child away. What if the egg was the surrogate mother's egg? Would it change your mind? Yeah. Anyone else? No, mostly not. Mostly not. But why is that so? Because I think that the argument in favor of the surrogate is obvious. Okay, she's the mother. She gave the birth of the child. She was with the child for 9 months. What is it that is more important for you? Anyone? Okay. Mhm. Uh-huh. So, the old Roman lawyers not only used to say that the father is always uncertain, but they also used to say that agreements must be kept. And this is this is actually one of the very basic principles of law. Sometimes people even say that because there's also something like a law anthropology, they compare different legal systems, not only like American and German legal systems, but also legal systems of some natural nations who live in, I don't know, in Papua New Guinea and so on. And they say, okay, in most of these, or maybe in every case, I don't know whether in every case, but probably yes, in every case, agreements are to be kept. So this is what is the most important for you. Okay. So, of course, there is no international. There are some international instruments that can be relevant, but there is no one unified regulation of surrogacy. But this was the case that was it was the first, or a similar case was the first case of surrogacy that was before the courts in the United States, and it was the so-called case of the baby M. You know, they usually don't use the real name, so they call the baby M. And it came up to the Supreme Court of the state of New Jersey, because different courts had different opinions. So there was an appeal and there was an appeal, and it came to the Supreme Court of New Jersey in 1988. And the court said the surrogacy contract is not enforceable, as it is against public policy to enforce it. So basically the court said something that is in stark contrast what most of you say. The court said, okay, this agreement is not illegal. They might enter into the agreement, and it's not illegal for the surrogate mother to give the child to the commissioning couple, but it is against public policy to enforce this agreement against the will of the surrogate mother. And the custody of the child must be based on the child's best interest. And this is important, and we will see that in Europe, the basic value underlying European courts' decisions is similar. The best interest of the child is what is crucial. So the court should ask, is it in the best interest of the child to stay with the surrogate mother or to be with the commissioning couple? But per se, the surrogacy contract is not enforceable. It is not in the whole United States even. In some states of the USA, courts tend to decide in a different way, and of course in different countries it is different. But this is I think the mainstream approach to it in most countries. So, and now let's scale the controversy up a bit. So cross-border surrogacy. Let's imagine this case, which is far from rare. It's a very obvious and very common case in the world of surrogacy. In country, let's call it country A, surrogacy is illegal. And there is a couple from the country A that wants to have a child, and they pay for surrogacy in a developing country B to a poor woman who wants to just be a surrogate mother, and their daughter is born. And they take the daughter home to their home country A. But the officials in the country A find out, and they say that that there is no legal parentage of this commissioning couple to the child. So the child should either be given to adoption, because there's no legal basis for them to raise the child. So there is a child in the country that has no legal basis. In law, everything has to have a legal basis, some legal reason for it to exist. And there is no legal reason for their legal parentage to exist. So the child should either be given for adoption or returned to the mother in country B. So again, would anyone agree that a child should be taken away from the commissioning couple? And don't be afraid to say that. No. Or yes.
So is it the parents do have the right then to adopt the baby if it goes?
Yeah. Yeah, they would probably have the right to adopt the baby, but they would mostly not be privileged in the process. And it's not easy to adopt a baby. So let's imagine that the baby would be given for adoption, and there might be many couples who want to adopt the baby, and they would just be one of these many couples. Uh-huh.
The issue is that they take the baby from pregnancy.
Yeah.
So that someone else
Uh-huh.
would take the baby while the baby was those parents.
Mm-hmm. Yeah, that's a great argument. It's not in the child's best interest because the child is already with this commissioning couple, and this commissioning couple has already proven that they really want to have this child. And this is very controversial to say, and it's usually not really said out loud because it's really on the brink of human trafficking. But cynically speaking, but I don't know whether it's pragmatically speaking, if you are willing to pay a lot of money for something, you probably want it. And if you are willing to pay a lot of money and to face many legal obstacles and other obstacles to have this biological child, then you probably really want to have this biological child. Sometimes there are studies, and that's not a lot of them, but sometimes there are studies who the children from which kind of couples have better like life success, whether from heterosexual couples and homosexual couples, and children from homosexual couples usually have a slightly better in average slightly better life success than from heterosexual couples. Why is that so? Are heterosexuals so inept in raising children? Probably not. But when a homosexual couple has a child, they probably had to really wanted a child and had to struggle to have the child. For many heterosexual couples, it is not the case. So, this might be a good argument for it. Can you think about any argument that would be at least a bit persuasive for you for returning the baby to the country of birth or to giving the baby up for adoption? Why would the state even want to take the baby away from the parents? Uh-huh. Yeah. If the mother, yeah, good. If the mother of the child wanted the child back, then we are actually back in the in one of the previous questions, but in a much more complicated settings actually. And we'll see that soon. We will see that some cases like this really happened, and it was really unclear who wants the child and who doesn't want the child, because the commissioning couple and the surrogate mother were saying something entirely different. So, in this case of cross-border surrogacy, I think this is just an outlook of these arguments. Of course, we could think of many more arguments probably, but what can be the arguments for legal relationship, legal parentage of the commissioning couple to the child? Okay, the right to private and family life. This is now let's zoom a bit in Europe. In Europe, we have the European Convention on Human Rights. It's the convention that is under the Council of Europe. It's not the European Union, it's a Council of Europe. There is some 48, I guess 48 member states. Almost every European country is a member of the Council of Europe. And according to or under Article 8 of this European Convention on Human Rights, everyone has the right to private and family life. And if this European Convention on Human Rights is violated, a person can, under some conditions, can issue a complaint to the European Court of Human Rights in Strasbourg, in France. This Article 8, the right to private and family life, has a very large scope. Many things can fit into the scope of this article. So, also in cases of surrogacy, even the Strasbourg court encountered cases when the parents claim that they have or it is part of their right to private and family life to raise the child, and they also claim that it is a part of the right of the child to private and family life, because of course the child also has the right to private and family life. And then the best interest of the child, as you already mentioned, yeah, we might argue that it is in the best interest of the child to stay with the commissioning couple. What are the arguments against the legal parentage? Okay, one of them might be the protection of values that are embodied in the legislation of country A. There is some reason why the country A prohibits surrogacy, so it doesn't really make sense from this point of view to prohibit surrogacy in this country and allow for cross-border surrogacy. It will lead to surrogacy, but only much more complicated and dangerous. The second one and the third one are very, very close to each other, and it's simply a protection of people from developing countries against exploitation and human trafficking, and protection both of women in those countries and of those babies. The issue with surrogate mothers in developing countries is quite straightforward. You can argue, and it's a very old argument in different settings. You can argue that if someone is very pure and has very limited life choices, and you offer them a lot of money for something, then it is the question whether they are really autonomous, whether they are really free in taking the offer. So imagine women from, I know, some poor villages in India or in Thailand, and they are given a lot of money, and for them it's a lot of money. For example, in India, it was documented that these ladies who agreed with being surrogate mothers were like concentrated in special houses that were run by the clinics, and they were under like constant supervision, and they had some rules they have to abide, and they sometimes had even limited medical attention, or all the medical attention was concentrated on the fetus or on the child and not really on them, and so on. So, and the second one, the protection of babies against exploitation and human trafficking. You just export a baby from this developing country abroad, and do you really know what is going to happen with the child? Right? This is another question that that is often raised by the critics. Let's get back to it later. Okay, this is quite long, but what does the European Court of Human Rights say? I don't think we need to read this all, but basically it says that the existence. This is what we touched upon already, because you said that it's in the best interest of the child to stay with the commissioning couple, and between the lines we might read that you might have been saying that the child has already some kind of family life with the couple. So the European Court of Human Rights thinks in a similar way, and it says that the existence of family life is based on many aspects, and in the absence of any biological link, the duration of shared cohabitation will be longer to establish a family life. But if there is a family life already established, in the case of this commissioning couple and this baby, then it will be more difficult for the state to separate the baby from the child. However, the state's refusal to recognize a parent-child relationship can be legal, even under the European Convention on Human Rights, because it can be in a pursuit of a legitimate aim, such as the protection of health and protection of the rights and freedoms of others, like the baby, or even the mother, the surrogate mother. Sorry, when the aim is to protect children and surrogate mothers, and what is paramount is the best interest of the child. So, in other words, what we have already concluded is the position that is taken by the European Court of Human Rights. What is important for the European Court of Human Rights is whether there is a biological link between the commissioning couple and the child. If there is a biological link, then the Court of Human Rights tends to be more protective of their parentage. However, it would not impose an excessive burden on children born through a gestational surrogacy arrangement abroad to expect the intended mother to initiate adoption proceedings. So basically, it is up to the state. It's up to the state to decide. The state might not even allow cross-border surrogacy. The state needs to respect the family life of children and the commissioning couple if this family life has already been established. And sometimes, if the state requires that the child is adopted, which means it's not given to free adoption as we were discussing, but it means that the legal parentage is not automatic. It's not per se, it doesn't arise in the moment of birth, but the intended parents needs to initiate adoption proceedings. This is also a possibility that is legal according to the European Court of Human Rights. And also, it will often be the regulation will often be grounded in the need to verify the identity of the child and protect him from human trafficking. And in all these cases, the margin of appreciation of the state is wide. What does it mean? The wide margin of appreciation means that the state has many options to decide how it will regulate the matter. So, according to the court in Strasbourg, the states are pretty free in regulating surrogacy. They don't have to legalize it. They just need to respect the family life, and they need to put the greatest emphasis on the best interest of the child. So, what about this case? A commissioning couple finds out that the fetus has Down syndrome, and the commissioning couple wants the surrogate mother to undergo abortion, and the mother doesn't want to undergo abortion. So when the child is born, the commissioning couple refuses to take over the baby, and they say, okay, we never wanted a baby with Down syndrome. We told you to undergo abortion. If you didn't, it's your choice. The child is yours, so good luck. What do you think about this? Do you think that the commissioning couple should have the right to abandon the child in this case?
That's why you should put PGTA in the
We discussed that, yeah. Okay. So, especially in developing countries, it's not usually so easy. Yeah. Uh-huh. 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 Okay. So, okay. So you basically say, okay, the both parties should be equal, and if one of them has a choice, the other should also have the choice. Okay. Uh-huh. Mm-hmm. Yeah. Uh-huh. Thank you.
Choose the option, choose the best for the child.
Mm-hmm.
It's like the parents have to
Yeah. Uh-huh.
they will do for the child if they don't want.
Yeah.
So,
Uh-huh. Uh-huh. Probably adoption or some kind of institution, maybe. Sometimes a part of these surrogacy agreements, a clause in these surrogacy agreements, obliges the surrogate mother to undergo abortion if there is any genetic defect of the child. What do you think about that? Do you think that this should be enforceable? Uh-huh. Uh-huh. Okay. Yeah, but if she agrees, she signs the document, but what if she then changes her mind? Okay. You know, this is sorry. There's a play of William Shakespeare where the guy agrees that under some condition they will use the knife to cut a lot of flesh from his body. And you know this in this play, they use like it was probably understood like a master legal move by Shakespeare and perhaps of people of his age. And they say, okay, but in this agreement, I promise to give you. I don't know, it was a pound or what, a lot of my flesh, because it would kill him, of course. But I never promised to give you any blood. So you can cut the flesh out of my body only if you don't spill one 1 ounce of blood, and of course it's not possible, so he's saved. Okay, this is in Shakespeare, and we don't need this legal artistry to say that such an agreement would not be enforceable, at least today. Why would it not be enforceable today?
Because again, it will go against the
Yeah, it's something like that, exactly. It's okay. Of course, it would be vastly illegal, and in our legal system, it's one cannot agree with grievous bodily harm or with being killed. But more generally, agreements are not enforceable if they are against what in the US they might call it public policy. In this country, we call it good morals. So if it is against good morals or whatever public policy is, whatever you want to call it, then you cannot enforce it. So sometimes the fact that you have signed the agreement is not as crucial as it might seem, because maybe the agreement was against the good morals. So the obvious argument is, okay, but it's against the good morals to force someone or to expect someone to undergo abortion if they don't want to. Perhaps the answer might be, okay, she of course doesn't have to undergo abortion because it's a violation of her physical integrity as well. But she then cannot force the parents to take the child. Let's get back to it then. But now let's see that this is the case that is not exactly rare, or it's not very usual, but it's not unheard of. There was a case in 2013. Have you heard about this case, the baby gamma? It's back in 2014, Thailand was one of the leading global hubs of surrogacy. It was like a huge global hub of surrogacy, international surrogacy, cross-border surrogacy, of course. And twins were born to surrogate mother. One of those twins, and the commissioning couple was from Australia. One of those twins was healthy, and it was taken to Australia, and the other one had Down syndrome. And the commissioning couple allegedly refused to take this child home. Later, it became more complicated because the commissioning couple said that the surrogate mother wanted to have the child and didn't want to give the child to them, even though it might be a bit suspicious that she wanted only the child with Down syndrome, but whatever. And they even won the case in Australian courts. They persuaded the court that they really didn't abandon the child, but this was a sensation in the media. And the couple, they were in some interviews a few years later, they said that they were the most hated couple in Australia. It was a huge uproar internationally, and it was probably like the final straw that led Thailand to ban international surrogacy. So this was very often cited as a case study of possible exploitation of those poor women and of dangers of international surrogacy in developing countries. Very famous case indeed. So what are the very basic options for regulation of surrogacy? Like on the most fundamental level, you can either make it legal. In some countries, all types of surrogacy are legal, meaning both altruistic and commercial surrogacy. For example, some states of the United States, like California, but also Ukraine or Russia, only altruistic surrogacy legal is also in some countries. They say, okay, commercial surrogacy is too dangerous, and only altruistic surrogacy should be permitted. Maybe the costs of the surrogate mother should be reimbursed, but there should be no financial remuneration, no financial award. This is, for example, the case of the United Kingdom, Australia, and some other countries. And in some countries, all surrogacy is illegal, including Germany, France, Italy, China. In China, it's like in many bio-legal, medical legal, or bioethical issues, China bans something, but also turns blind eye to it. So surrogacy is practiced in China nonetheless, but it's formally illegal in China. But in many countries, it really is illegal, and this prohibition is enforced. And there are many countries with no specific regulations, including the Czech Republic. Do you see a fundamental difference between the permissibility of altruistic and commercial surrogacy? Yeah, you see. You would be for the prohibition of commercial surrogacy, but you would make altruistic surrogacy legal.
I think I would do in the way where you said that if there would be some reimbursement for the
Yeah.
because I think also in pregnancy, like the economic demand
Yeah, sure. Yeah.
But I think the question even for me, it's not like 100% yes or no. Because keeping some.
Okay. Okay. So basically, you wouldn't want the women to sell out their pregnancy. Yeah. Okay. Which is basically the argument against commercial surrogacy. Okay. Anyone else? Is this a similar opinion? Altruistic, yes. Commercial, no. No. So mostly you would allow commercial surrogacy as well. Of course, this is another question. There are countries that specifically allow commercial surrogacy within the country, but not cross-border surrogacy. Yeah, and it's also an option, a regulatory option to do this. To say, okay, we don't want to exploit, but in our country, we believe that we can manage to enforce some basic rules for surrogacy, so we only allow this. Yeah, it's also an option, and it's a very good mention, because this is also very discussed pretty much. Yeah. So, and as you can see, a lot of countries simply don't regulate it in any specific way. The crucial word is specific, because of course there are many laws and many rules that and many norms that are relevant for surrogacy. You cannot violate human rights of the surrogate mother. You cannot or any other rights of the surrogate mother when it comes to it. You cannot violate the rights of the commissioning couple and so on. But the question is, do we have and do we need a specific regulation? What are the surrogacy hubs? Until mid 2010s, probably, it was mainly in Southeast Asia, as we talked about Thailand. Thailand was a huge hub of surrogacy. In 2015, cross-border surrogacy was banned in Thailand. Now they discuss lifting this ban, but it was banned. So most of cross-border surrogacy moved to India. Soon after that, in India, it is quite a messy political process, but let's say it banned commercial surrogacy. So it moved to Cambodia, a small country of Cambodia, and Cambodia banned all surrogacy in 2016. So it was really like chasing the country in South Asia, which still had commercial surrogacy legal. Why it was in Southeast Asia? Because of the coast, of course. It was cheaper to have surrogacy in Southeast Asia. And now a huge hub of surrogacy is Ukraine. It, of course, mainly before the war, it was very big, but still it is a hub of surrogacy. Then Georgia, sorry, there's a mistype in Georgia. A part of Ukrainian surrogacy moved to Georgia when the war broke out. Then Mexico, USA. The problem, or a problem with USA, of course, is that it is much more costly. You can see in Mexico or Ukraine or many other countries, the cost of surrogacy is about $50,000 to $70,000. In USA, it's about $200,000. So you can say you can have 3 children for the cost of 1 if you go from Mexico. So what are the key questions that the legislator who wants to enact a specific regulation of surrogacy needs to answer? So what are these key questions? Based on what we are talking about, what do you think are the key questions, the most important questions that need to be answered, that need to be solved? Who is the mother? Who is eligible for surrogacy? Right? Who can be the intended mother? Sure. What else? What about the surrogate mother? Should there be any criteria for the surrogate mother? There should be, right? Of course. Like, yeah, in the right health condition, perhaps of a certain age. Yeah. This is another interesting question. Can the commissioning couple enforce in any way possible clause about a healthy life? There is a surrogate mother who wants to have a drink or two from time to time and so on, and she bears a child that will be raised by other people, and they don't want her to make the risk of any health conditions higher than necessary. So they don't want her to undergo any risk, but she does want to. Should they be able to prevent her, and how? How can they do that? What can be some other questions? What do you think? Yeah. Okay, thank you. This is great. We talked about it a bit, but now let's ask this question straightforward. What do you think should have the choice? The mother, yeah. And from the legal point of view, absolutely, it's only the mother. It's only the mother. To force someone to have abortion is like a blatant violation of their physical integrity, of course. But at least in countries where abortion is legal, they also cannot really prevent her from undergoing abortion if she wants to. So it's really up to her. So what else? Do you have any other ideas? Other questions? Key questions we talked about? Great. That's great. That's great. What if the couple separates and suddenly there is no one who wants the child? And this can happen. And this can happen. And it happened. The couple might separate. The couple might change their minds. We talked about the surrogate mother changing her mind. But what if the couple changes their mind? Okay, they have probably paid a lot of money, but still this can happen. The couple might die. Or there might be something entirely different. In Ukraine, when the war broke out, there was a lot of surrogate mothers who, in the first months of war, were not able to get the baby out of the country in a safe way. So something can happen, anything can happen that will prevent the surrogate agreement to be fulfilled. And what now? What to do now? Yeah, exactly. Yeah. What did they change mind? What did they change mind? So, of course, the obvious questions. Should we allow for commercial surrogacy? We've discussed it. Should we allow for gestational or only traditional surrogacy? Would you have a problem with the idea of gestational surrogacy, or on the other hand, of traditional surrogacy? So would anyone have the problem with gestational surrogacy, which means that the surrogate mother, the gestational mother, is not the genetic mother? Do you think this is okay? It's all right for you? Okay, it's all right. Do you think it's all right if the gestational mother is the genetic mother? Would anyone have a problem with this? No. Soon I will show you the first principle, or the principles that are now published by the Ministry of Justice of the Czech Republic, and they say, okay, the gestational mother, if we manage to enact this regulation, the gestational mother will not be allowed to be the genetic mother, because they simply don't want to, they actually want to distinguish between these two roles. They don't want the woman to give a child is totally her own to someone else. Is this reasonable? Is this justifiable? Is this a good idea or not?
When you say this, the thing that came to my mind is that maybe it's easier or complicated the situation more, because then there will be potentially surrogate mother and biological mother.
Yeah, exactly. Yeah, they suppose that the genetic mother would either be the social mother, or if she cannot be the social mother, then it would be some donor who would not want to have anything in common with the child. But of course, it begs for complication in some cases. The more complicated, the more complications may arise, of course. Parental rights, who are the parents? From what moment are the parents from the legal perspective? Does the surrogate have any legal relationship with the child? If she's not the mother, does she have any legal relationship with the child? And of course, cross-border surrogacy and many other questions that you have already mentioned. So I think we can be sure, and I will now just briefly show you the Czech legislation that we can use now, and the first proposal that is now being discussed by the government. But I think we can be fairly sure that even if a specific regulation is enacted, it will not be enough, and we will need to interpret and reinterpret some other norms from different branches of law, like contractual law and perhaps tort law. Who is responsible? Who is liable when something goes bad? And similar questions. So Czech legislation is almost none. There's no specific regulation. There is the only explicit mention of surrogacy in the whole Czech legal system. And it is in the civil code when it says that adoption is excluded between persons related to each other in the direct line and between siblings. This does not apply in the case of surrogacy. So the legislator, when enacting the civil code, and the civil code came into force in 2014, it's a relatively new civil code. It was enacted in 2012, and we can see that the legislator was probably thinking something along the lines: okay, there is this thing called surrogacy. We don't want it to be illegal. We want to help those people who undergo probably altruistic surrogacy. So, for example, if a sister gives birth to a child for her sister, we will allow it, and we will make this exception that in these cases of surrogacy, adoption is possible even in the direct line or between siblings. Okay, and that's all. So the legislator obviously wanted surrogacy to be legal, and it is legal in law, in democracy. One of the basic legal principles is if something is not prohibited, then it is legal. So surrogacy is legal. But that's about it. Yeah, you wanted to ask? Uh-huh. Well, I have to admit that you are better informed than I am. Of course, this is really, I don't know. Of course, this might be true in any case, but I don't know. I think still we have we lawyers also have something that is called, when we interpret law, we have what we call a presumption of rational legislator. Because sometimes you can open, I don't think this is this case, but sometimes you can open the legal regulation and say, well, what the hell is this? And this means that before you say, okay, this is an obvious error, because it happens, and sometimes we say, okay, this is an obvious error. The legislator obviously didn't think it through. But before we do that, we need to suppose that the legislator is rational and try to find a rational interpretation of this. So I think even if this was true, it doesn't change anything. But sorry, I don't know about this gossip. It's a good one. Thank you. So now some more general regulation that also applies to it. The regulation of IVF. Assisted reproduction is only permitted for couples, a man and a woman. Only a man and a woman, a couple of men and women. Virtually any man and woman can come to a fertility clinic and say, okay, we are a couple, and they say, okay, good. No one cares. No one cares. So there are cases when single women or lesbian couples had IVF because they managed to have some friend come to the clinic and say, okay, I'm part of this couple. They don't have to be married. They're just a couple. However, the mother is always the woman who gave birth. This is literally in the civil code. The mother is always the woman who gave birth. The mother is always certain, at least according to law. However, if the woman is married, her husband is presumed to be the father. And if she is not married, the man who grants written consent with assisted reproduction is presumed to be the father. And the man can only deny parenthood in this case if the man granted written consent, and written consent is required for assisted reproduction. So, for example, if I wanted to help out my lesbian female friend and I went to the fertility clinic and say, okay, I'm her boyfriend, they wouldn't ask anything, they just don't care. They say, okay, give us the money, we will give you a chance to have a baby. But I would be legally presumed to be the father, and I would only be able to deny parentage if I proved that the woman did not get pregnant from assisted reproduction, which is quite different to do, right? So virtually any man who gives this written consent with assisted reproduction is a father from the legal perspective. So this is the current Czech regulation. As you can see, what is the Czech practice? It is estimated that there are some, I don't know, 30, 40, 50 children born from surrogacy every year, but they are not registered anywhere. We just don't know. This is just an assumption. There might be less, there might be more. We don't know. The fact is that surrogacy happens in the Czech Republic, and it's not a very often way to have a child, but it's not unheard of. Intended parents legally adopt the baby. So under Czech law, if you have a child and you want to give the child to adoption, you can either give it to free adoption, or you can specify who should be the parents. And then if they are eligible, if they meet all the criteria set by the law, they are the parents. So this is how it works in the Czech Republic. The surrogate mother gives the child to adoption, and the intended parents adopt the child. And the contractual obligation of the mother is not enforceable. It's contrary to good morals. It's contrary to good morals. So if the mother changed her mind, and this is not written in any book, but I've never yet encountered a lawyer who would have a different opinion. Like it seems obvious from how we understand good morals, how we understand law, how we understand fundamental rights, that you wouldn't be able to force the gestational mother to give the child up, because she's the mother. The mother is always the woman who gave birth. So you cannot force the mother to give the child to adoption. The same applies to other obligations that would interfere with her autonomy of will and bodily integrity, like the obligation to undergo abortion, to live in a healthy way, and so on and so similar. And this is just a side note. According to the Strasbourg Court of Human Rights, a legal presumption at the moment of a child's birth that the woman who carried the child is the child's mother is all right for the Strasbourg Court. So this is in line with the European system of human rights protection. It's in scope of the wide margin of appreciation of the state. There's nothing illegal in here from the perspective of international law. We still have a bit time, I guess. Yeah. Okay, sorry. It's okay. Sorry. Okay, just let's be brave now. Okay, there was okay, good, thank you. There was a kind of a scandal 2 years ago when the newspapers found out that there was a group from Ukraine that was involved in what some call a legitimate surrogacy business, some call it human trafficking, when they used Ukrainian women as surrogate mothers. The IVF was carried out in Ukraine. They were pregnant, but then they came to the Czech Republic to some of maternity wards in Czech hospitals. They gave birth in the Czech Republic, and then the commissioning couples took the children to their home countries anywhere in the world. And it is based on this in Ukraine, a criminal proceedings was started against some members of this group. But the reasons for why it was a scandal in part of Czech public and part of Czech media, and the reasons for why they are criminally prosecuted in Ukraine is very different. Because in the Czech Republic, there was uproar because of the commercial nature, because Czech law doesn't specifically prohibit commercial surrogacy, and even the police said, okay, we cannot prosecute them because what they did, commercial surrogacy, is not illegal in the Czech Republic. It's not illegal, and a part of the media were saying, okay, that's a loop in the law, and we need to ban it, and it was all the rage. But it's not illegal. But there was an uproar on part of the public because of that, and also because of there were allegedly no safeguards against human trafficking, that they didn't care where the child, okay, here is the child, we have the money, you have the child, bye, take care. In Ukraine, commercial surrogacy is legal, and it's even, I think we can say it's supported by the state. But according to Ukrainian law, surrogacy is only permitted for married couples who cannot have children due to medical reasons, due to medical condition. And it was not the case in here. There were like homosexual couples, there were single individuals, and so on. So the difference was very different. Czech society tends to be, the majority of Czech society tends to be very liberal, or well, let's say in some cases very liberal, and they usually don't have a big problem with this, and they definitely don't have a big problem with unmarried couples having kids. So it's interesting how different cultures take a very different perspective on the matter. And now my question is for you: do you think that when I talked about a Czech regulation and Czech practice, do you think that we need a specific regulation? What do you think? You think we do need it? Why do you think so? Mm-hmm.
Much more chaotic.
Uh-huh. Mm-hmm. Yeah. So there might be some open questions that need to be answered in advance.
But the way I do it, sometimes when there is like a direct approach, it may be better than when it's, for example, in streets or in shadow.
Mm-hmm.
And make it more complicated.
Mm-hmm. Thank you. Any other idea? This is actually quite controversial among lawyers. Yeah.
Thinking don't.
Yeah.
Because it seems it works all right.
Yeah.
Like maybe if we do something
Uh-huh.
more complicated, or it's just such a big problem.
Yeah.
Be like
Yeah.
done specifically for the couple, not like
Okay.
something.
Okay. So you are basically saying that the specific regulation could, like paradoxically, could lead to a less individual approach in some cases.
It's a really great idea to like, you said it's they are thinking this, matter can
Yeah.
I don't know if it's like the right way, and
Yeah.
choose something
Uh-huh.
and then it will be like forever, or it will be really difficult to change.
Okay, good. So what do you think? We now have to. I love it because we now have two arguments against each other. What would be? Yeah.
Seems to me maybe the simplest solution that and yeah, to regulate it just
Yeah. Yeah. Exactly.
go for different countries and it will be
Mm. Yeah. So you will ban it too.
that and then
Yeah. Yeah. But. Uh huh. Uh huh. Thank you. Uh huh. Mm-hmm. Mm-hmm. Okay. Yeah. Uh huh. This is exactly the. Uh huh. Uh huh. Uh huh. Yeah. Uh huh. Uh huh. Okay. Uh huh. Okay. Thank you very much. First, for your opinion. It's great to have these different opinions. I love it. Second, you exactly say what the critics of surrogacy say, that it boils down to human trafficking, at least commercial surrogacy, in the eyes of its opponents. It boils down to a kind of a legal human trafficking. And yeah, of course, I agree with this, that any regulation will open a lot of questions. Of course, the answer could be, okay, the easiest way to almost anything is to ban it, but still there are some social phenomena that you cannot really ban. In surrogacy, it's more up to the values and up to these like core political and moral values and moral views, and that's why it's so controversial. If we stick to these two opens, okay, if I presented you, if you, so some of you are Czech, some of you are from foreign countries, so now let's assume that for today you are the parliament of the Czech Republic. And you are voting either for leaving it as it is or for changing the regulation. Now, I'm not asking how to make the change, but adopting specific regulation. The argument for the specific regulation is obvious. Yeah, okay, we need to prevent chaos. The argument against the specific regulation is, or there are more arguments. One of them is, as you mentioned, and some lawyers already said, okay, this is so marginal from the perspective of the whole society, that for the law, the best thing to do is not to ignore it, but simply to apply general rules to it. And the other problem might be, okay, things can get more complicated, because even if we had the best intention, we can complicate things unnecessarily by adopting some special rules. And another argument might be, okay, if we open the political discussion, we are simply endangering something that works, and no one really, no one involved really cries for the change. Usually, it's the media or some people from outside who want the change. So let's just make this like mood voting. Who would vote for opening the discussion on the specific regulation? Okay, and who against it? Okay, there is. So it's about half. Okay, that's good. So now just very briefly, and we will end. I'm sorry for that. A proposed Czech regulation in August 2024, right now, actually, the Ministry of Justice submitted to the government a plan for regulation of surrogacy, and it's debated in the government. It's not even in the legislation. And frankly, we have general elections next autumn, and a bill which is not enacted before the general elections simply ceases to exist. So I think it's virtually impossible. It's realistically impossible for the parliament to enact this regulation. So I understand it more as a way to open a discussion, like optimistically saying it's a way to open discussion, pessimistically saying it's a way to show that we are doing something before the election. But whatever, this is just something that doesn't have a lot of chance to really become the law. But the plan can be perhaps the next government will take it and the next parliament will just continue in this effort. Who knows? Altruistic, only altruistic surrogacy. Only for medical indication. Only for medical indication of the intended parents. There should be criteria for surrogate mother, but we already have them. You can undergo IVF if you are of a certain age, if you don't have certain medical conditions, and so on. There needs to be genetic link to the intended parents. The surrogate's own eggs must not be used. We already talked about it. And the germ cells of at least one of the intended parents must be used. This is interesting. Every instance of every case of surrogacy would require prior court approval. And then the intended parents will be legally recognized as the child's legal parents from the moment of birth. So it will be an exception. It would be an exception from the rule that the woman who gave birth is always the mother, and the surrogate mother will not have any legal relationship with the child. Yeah, it opens a lot of questions, and I will leave it up to you whether it's worth it and how these questions should be answered. So we already discussed this a bit, so I think I can just leave it in here. And thank you very much for your attention and for your great inputs and for your great questions. If you had any other questions, I believe we still have 5-ish minutes to your questions if you have any.